Perfect. Good evening, and welcome to the Town of Killenly, Connecticut Zoning Board of Appeals. Thursday, February 13th, 2025, our regular meeting. The time is 7:02. We're going to start the meeting. We'll have our roll call.
David Izzo, present online. Can you hear us, David?
You might be muted.
Lynn LaBerge,
Here.
William Menke,
Here.
Jared Peachy,
Here.
and Andrew Farner.
Here. We get to see him. We're going to go on to Article 3, Citizens Participation. Public comment can be emailed to publiccomment@killenlyct.gov or mailed to the Town of Killenly, 172 Main Street, Killenly, Connecticut, 06239, on or before the meeting. All public comments received prior to 2 p.m. on the day of the meeting will be posted on the town's website, www.killenlyct.gov. Jonathan, did we have any public comment?
We received no public comment. I am seeing Dave now on there. Dave, can you unmute?
Yes, I'm here. I can hear you.
Okay, perfect. Thank you.
Thank you.
And we have no one else on for citizens' comment. I believe everyone here in the room are with applicants.
Okay. On to Article 4, Public Hearings. To participate in the public hearing, the public may join the meeting via WebEx or in person at townofkillenly.mywebex.com/townofkillenly.my. You have that link up on Facebook?
That link is on the Town of Killenly
Website? Okay.
Under the Zoning Board of Appeals. So if anyone wants to pull up the agenda, they're welcome to go on there, and they can join at any time. There's also an option to join by phone.
The join by phone number is 1-415-655-0001. On to application 25845 of Ruth Halvland. Alfred and Susan Chartier are the owners to vary the Town of Killenly zoning regulations, 450 dimensional requirement, Table A minimum front setback from 75 feet to 48 feet for a 12 by 24 deck at 4 Shawnee Drive on the GIS map 246 lot 17 RD zone. The applicants here?
Hi, my name is Ruth Haviland. I'm here with Nick and Sue Chartier. We are requesting that the town allow them to build a deck that's larger than what they have. Right now, they have an 8 by 14 deck. They want to extend it to 12 by 24 to extend their living space. Their lot is non-conforming. They are on a corner lot of Shawnee and Snake Meadow Road, so they cannot, they have frontages on both sides. The reason they want to go this way is because the other side of the deck that they have now has their generator, their propane tanks, the well, their air conditioning unit, so there's no way to go the other direction. So we're asking for this to be extended to that side. Mrs. Chartier also wanted to have this happen because at some point she would like to extend her front walkway and go around to the back so she has access. That is not in the plans for right now, but future project for them.
So in looking at the application, the subdivision, there predated zoning. Shortly after the home was built, zoning was established. At the time in the rural development zone, the front setback was 40 feet. That got increased in the 80s to 75 feet, which now places the home inside of the front setback, at least on the Squaw Rock?
Snake Meadow?
Snake Meadow side. And that's the side they're looking to move towards. That's the reason for the application, because as it stands right now, zoning wouldn't be able to approve it without a variance. And I will agree with the applicant in terms of the house lot size being 0.6 of an acre. That would be legal nonconforming. Typical house lot size would be 1.84 acres for the rural development zone. So it's half, less than half of that.
Do you have a septic system?
They do, yes.
Yeah, sorry, but it's quite close to the, if we were gonna push towards the neighbor side, not the Shawnee side or Snake Meadow side, we would,
It's near the rear
Probably-
property line.
yeah, we would probably have an issue going into the septic.
The packet does have from the applicant a sketch from NDDH showing the approximate location of the septic system. And for comparison, it does show the existing deck location. There's also a photo with the application.
Okay, there it is.
Of the back of the home that shows a generator, HVAC system, propane tanks, all on that same side, limiting the ability to expand in that direction.
Is there any more comment from anybody in the public? For the walkway, though, is that something they have to come back to do, or would it be in the setback that we're,
That would be something we would have to come back and check on.
okay,
If just a walkway, like a concrete walkway around the site, that wouldn't have to meet setbacks.
okay. So I was just wondering if it was going from this side.
It would only count towards lot coverage.
Okay. Okay. Any discussion?
I do want to see if I can share something real quick for you guys. Hold on here. Don't want it to lag on me here. There we go. Share the window. So for Shawnee Drive, this is the GIS. One of the things that wasn't quite shown in that aerial is the next house up being 255 Snake Meadow Road. That's also an older home, very similar size in the same zone. And just looking at that front, the distance from the front setback, I just wanted to point that out to the board, particularly that the proposed deck wouldn't even be going as close to the road as a neighboring home
Okay.
in the same zone.
And there are other properties with decks, I would assume, in the
Y-
area?
Definitely, there are other decks, even south of that, you can see a home that would also be much closer to the road. A bunch of the homes have decks or pools in the area, but most of them are similar style construction, built all in the same vintage. I'll take that down. Unless you guys want anything else, I'm gonna take that.
No, we're all set.
So just to let you know, some of what we have to base our decisions on is that the variance has to be shown not to affect substantially or compromise the zoning plan for the area, and that adherence to the strict letter of the zoning ordinance would cause unusual hardship and unnecessary to carrying out the general purposes of the zoning plan and also that proof of exceptional difficulty or unusual hardship because of peculiar characteristics of the parcel of land is a condition precedent to the granting of a zoning variance. So I'll just let you know what we have to base, what we used to base our decision on.
Mhm.
Anything from David?
David is here. No, I'm all set. I'm familiar with the area. I do have a friend that lives on that road down on the far left-hand side. So I am familiar with that house and where the deck would go. I don't have any problems with that.
Okay. Guess an action needs to be made.
So you be, if you want, at this time, you could close the public hearing, and then you would vote on it later on the agenda under Article 5, unfinished business.
Do we have a motion to close application 25845?
So moved.
David is I'll make a motion to close same.
She can say. Okay.
Then if you could do a roll call vote, because you do have one member remote.
Oh, yes. Joanne, would you like to?
David Izzo? Roll call vote.
Aye.
Lynn LaBerge?
Yes.
William Mengy?
Yes.
Jared Peachy?
Yes.
And Andrew Farner.
Yes.
Motion carries unanimously.
So that application's closed. We'll be back to, we're going to go to application 25846 of Charles Caddy of Isabel Intercontinental LLC, owner, to vary the Borough of Daleson zoning regulations 440.2 prohibiting use to allow for a residential occupation on the first floor at 13 Water Street, the GIS map 198, lot 53, in a CBD zone. Good evening.
Good evening. I wrote this down because I'm not good at improvising, so bear with me. Good evening, members of the Zoning Board of Appeals. My name is Charles Cady, and I'm here representing Isabel Intercontinental LLC, the owners of the 13 Water Street property. Thank you for the opportunity to present our appeal for an exception to zoning regulation 440.2, which prohibits first floor residential use in the central business district. We strongly believe that an exception for this property is justified and beneficial to the town for three key reasons. First, the precedent has already been set. The board has granted similar exceptions, most notably at 29 Mechanic Street, where the VFW building was converted into residential apartments. And this shows under the right conditions, first floor residential use can be an appropriate and positive change. Second, this property's location makes commercial use difficult, or commercial appeal, I should say, because it's set back from the busier business district and is surrounded primarily by residential properties, both one and two-story. This negatively impacts the ability to attract commercial tenants, making a residential conversion the most practical and productive use of the property. Third, allowing this exemption supports the community's needs without undue burden on the infrastructure. As a commercial property, the building's allowable occupancy is 37 people. With a water usage of up to 1,369 gallons daily and sewer discharge of roughly 740 gallons. In comparison, residential use would result in a modest increase in water and sewer demand, about 25% more water use and approximately 60% more sewer discharge, both within sustainable limits. In summary, this appeal aligns with previous zoning decisions, addresses practical limitations of the specific property, and serves the town's growing need for affordable housing without significant impact on the infrastructure. We respectfully ask for your approval of this exception and appreciate your time and consideration. I did notice, John brought my attention to some comments from the town engineer, which is certainly legitimate concerns because the numbers that that I had used in my comparisons are really subjective to the end configuration of the property, and that has not been a priority at this point in time. We didn't want to pursue getting too deep into it without getting some initial approval subject to the final residential layout. So that will have, the number of bedrooms, et cetera, will have a big impact on the potential sewer usage as well as water usage as well.
So I know the applicant used 29, I believe, Mechanic Street as a comparable. That is in a different district, so that's on the high density. But I understand the reasoning.
Yeah,
right?
yeah.
I will say a great comparison on that street, and the applicant shows that on his plan in terms of other uses inside that district. 20 Water Street, for instance, is residential on the first floor. It's a triple decker. Most of the homes that are residential uses, I believe actually all the ones that are indicated as residential uses on the submitted plan are on the first floor, and they are in central business district. In that tight area, I don't believe there's a mixture of uses. It's either residential or it's commercial.
And I believe that 20 Water Street had the same thing, and it was voted to take and allow them to do residential on that first floor.
Yeah, so 20 Water Street has interesting history. It was once owned actually by the town of Killingly. The town of Killingly placed a restriction on that first floor unit because they wanted to see potentially commercial there. So they put a deed restriction. Ultimately, that building sat vacant for a long time. We couldn't get anyone to really bite or revitalize it. Ultimately, a local contractor, apartment owner, did take over that property. We met with that individual and we looked at that first floor space to really judge the viability of a commercial use. This is a few years ago, six or so years ago.
I was on the town council.
Yes, yep. And ultimately, what we found was the unit was like a time capsule from the 1970s, complete with shag carpeting and all, and it was definitely residential in nature. Normally, we would speak to the grandfathering of uses, and wouldn't take into account a deed restriction. Zoning doesn't look at deed restrictions. However, the deed restriction was from my employer. So ultimately, the Economic Development Commission weighed in, and it went to the town council. The town council voted and removed that restriction and allowed the residential use to be reestablished and renovated. And that building, I believe, has full occupancy at this time.
So based on what I'm reading from the town engineer, which was new to me this evening, what I think would make the most sense is a conditional approval based on bringing the town engineer on board after the fact. If you allowed us to proceed on that condition, I think that would be acceptable for us. certainly, to pursue the matter further. And, if we can bring him on board, then we'd be looking for full approval. And if not, then it would go into some other type of plan, I guess. I don't know. Not a lot of people looking for, for a space, office space or commercial space like that, especially in that area, so.
And on the side of the building, there's also plenty of parking
Yes,
on the right.
yep. Yeah, we do meet the parking needs for the number of apartments that would be, we're talking 4 apartments, 2 up, 2 down at the most.
Thank you.
Is that this one? Right here.
Yeah, just
Oh,
sharing on
parking.
the screen there, I think it's
Okay.
also in your packet.
Yep.
GIS image, just
Okay.
showing the paved parking lot that offers off-street parking on the subject property.
Okay.
I assume that's municipal parking that's right next to it and that belongs to the
Yeah,
town, correct?
I realized my mic was off, but yes,
Yeah.
so there is parking on site, as
Yeah.
demonstrated on the GIS.
Yeah.
And then there is off-street or on-street, depending how you look at it, parking that is municipally owned in that area. The borough regulations do allow for the use of that type of parking. Can be problematic in a snowstorm when we do parking
Right.
bans, so having the on-site parking would be extremely beneficial, particularly for residential use when somebody wants to park there during the night.
Comparatively, was it 20 Water Street that you
Yeah,
had talked about it
20
6 years
20
ago.
Water Street is right here, right
Okay.
across the street.
And that has no parking?
It utilizes some parking on an abutting property. It has
66.
very limited parking around it. But I believe they contract with the abutting property on 103 Main behind Pourings and Passages in there. This parking lot has actually been a little bit more improved since this image was taken.
Well, when that was approved, was that before or after the moratorium was in place?
20 Water Street?
Yeah.
So 20 Water Street predates the moratorium.
Okay.
So the moratorium right now has had some updates. The moratorium does allow the town engineer to look at each application and act accordingly. He can weigh in on it. He has the ability to also push an application back to the commission, the sewer commission. But he's going to be looking at what was the utilization of the space in terms of sewer flow, check, confirm the numbers, and then the projected flows.
Okay.
That's, as the applicant indicated, there is a correspondence that was introduced, into the record from the town engineer, who suggested if, based on the numbers, he didn't agree with the numbers as they were submitted. However, he understood there were a lot of variables, particularly number of units, bedrooms, etc. And if you, speaking to the board, want to make a conditional approval based upon an engineering review of new data, that would be okay with him. So that was from Dave Capascion, the town engineer.
I mean, I understand your dilemma where, it's not worth, you're looking for a little latitude to get into it.
Yeah, the latitude to develop, a plan that's going to meet with his approval would be the goal once, there's no, if we don't have a conditional approval, there's no point in pursuing it any further. But, having a conditional approval gives us the ability to meet his goals, at least anyhow. So obviously, it's not going to move forward without his approval. So, we just have to be able to get to that next step.
And correct me if I'm wrong, I believe the proposed use in totality for the building is 3 units as of right now. But the variance that you're seeking is just whether or not residential use can occur on that first floor.
That is correct, yeah. That's really the obstacle we need to get beyond to develop the plan further, because, it's gonna take a lot of thought to come up with a new plan for the property if that's not feasible.
Yeah, and the borough regulations tie residential units to number of parking spots. So ultimately, that would be what would be looked at before any future permitting, if the variance was granted, having adequate off-street parking or shared parking in the vicinity that, they could get a parking pass or something for those residents. The state has done some updates on the parking. It's in a slight conflict with the borough and the town regulations. So normally a studio apartment up to a 1-bedroom apartment would be capped at one spot. And anything 2 bedrooms and more, you can't require more than 2 spots, is my understanding of the change from the legislature.
David, was there any questions from you, David?
David Izzo here. No, I do not have any questions. I went by there and looked at it. I can understand the gentleman's point of view, what he wants to do. Well, I don't have any issues with it.
Okay. Do you want to state that again? Okay. Okay. Do we have a motion to close application 25846?
Bill Mengy, I'll make a motion to close application number 25-846.
David Izzo, seconded.
And for clarity, we're talking about closing just the public hearing.
Just the public hearing. Joanne, we'll do a roll call vote.
Lynn LaBerge?
Yes.
William Mengy?
Yes.
Jared Peachy?
Yes.
David Izzo?
Yes.
Andrew Farner?
Yes.
Motion carries unanimously.
On to Article 5, unfinished business. We're going to open up unfinished business, application 25845 of Ruth Halfley, Alfred and Susan Chartier, owners, to vary the town of Killenly zoning regulations on the 450. Dimensional requirement, Table A, minimum front setback from 75 feet to 48 feet for a 12 by 24 deck at 4 Shawnee Drive, the GIS map 246, lot 17, in the RD zone. Discussion.
William Mengy, I make a motion to approve application 25-845 based on the fact that the property predates zoning, as well as the hardship of septic location, as well as utilities.
David Izzo, second that.
Roll call vote?
William Mengy?
Yes.
Jared Peachy?
Yes.
David Izzo?
Yes.
Lynn LaBerge?
Yes.
Andrew Farner?
Yes.
Motion carries unanimously.
Just so you know, I'll end up putting together a legal ad for the variance, and I'll be in contact for recording with a approval letter or recording sheet to be placed on file with the town clerk. As soon as the legal advertisement goes into, we've used an Orange Bulletin, that will trigger what's called a 15-day appeal period. At the closure of the 15-day appeal period, we'll have you record the decision letter with the town clerk for a fee. And that will be in there. But otherwise, we'll be in touch.
All right, thank you so much.
On to unfinished business, application 25846 of Charles Caddy, Isabel Intercontinental LLC owner, to vary the Borough of Danielson zoning regulations of the 440.2, prohibit use to allow for a residential occupancy on the first floor at 13 Water Street on a GIS map 198, lot 53, in a CBD zone.
I'll make a motion that we approve application 25-846, the special conditions that exist are particular to the land structure. Also in that area, it has already been allowed to take and change a first floor from business to residential. The applicant didn't have anything to do with what happened with the property, but I will take, the approval will be on the condition based upon an engineering review of new data.
I'll second that.
Roll call vote.
Yes.
David Izzo,
Yes.
Linda Burge,
Yes?
William Mengy,
Yes.
Andrew Farner.
Yes.
Motion carries unanimously.
Same thing for you?
Very good.
Yep.
Thank you.
Have a good night.
On to Article 6, new business, training. Land use presentation regarding variances by the town attorney, Kenneth R. Slater Jr., Esquire, from Halloran and Sage. Good evening,
Good evening,
Halloran.
folks. How are you?
Tired.
Ken, do you want me to pass my laptop over and you can?
If you don't mind, that'd be,
Yeah, that's fine.
be
Yep.
great. Or either that or the mouse.
Yep,
whatever
yeah,
you
just give
want.
me 1 second.
I just get this back.
Want me to just do it with the mouse? And then just do a special-
No.
It's more specific to us.
Yep.
You should be able to just scroll right down. I'm gonna try to make that bigger.
Okay. You can do that.
Did they start back up again? But that's when they come back around? Okay.
How are you folks tonight, other than tired?
Good.
So I'm usually here sitting with the Planning and Zoning Commission. I had a training session with them recently, and everybody thought it'd be a good opportunity to come, since I haven't done one with your board, to come and do a presentation regarding the Zoning Board of Appeals. A lot of the stuff you're familiar with, but I usually find that when we do this exercise with, when the Planning and Zoning Commission or Wetlands Commission or ZBA, there's usually things that are refreshers or might spark some questions. So I encourage you to stop me in the midst of this, and we can have a dialogue and discuss any of the points I'm getting to. I will give you an overview. I'm going to touch on why you exist. A lot of the presentation is going to be the thing that you struggle with the most, which is hardship and what that means and what it's about. And I'll also touch upon appeals from zoning enforcement decisions, which I don't think you get a lot of those, but to the extent that you will, at least we'll give you an overview on that. So the statute that allows zoning regulations in Connecticut has in it the requirement that if a town adopts zoning, it has to have your board. It has to have a ZBA. The idea was the concern that there was a one-size-fit-all zoning regulation. There were going to be some properties that would be adversely affected in a way that they would need relief from a board like yours. And then they coupled with that an opportunity. Jonathan made a decision as a CEO. People need to be afforded an opportunity to appeal that to your board before it would potentially be appealed to zoning enforcement. To Superior Court. So the specific statutory authority for variances, which is most of what you do, and in fact from a nod it sounds like virtually all that you do, is a variance can be granted as long as the variance is consistent with the general purpose and intent, with due consideration for conserving public health, safety, convenience, welfare, property values, solely with respect to the parcel of land where, owing to conditions especially affecting such parcel but not affecting generally the district in which it was situated, a literal enforcement of such. So it's a very dense definition or dense section of the general statutes that is the heart of what a variance is, and I'll get more to that in a little while. So ZBAs are made up of 5 members, and 3 alternates, and you can have an ordinance or a charter that establishes how you're elected or appointed. But one thing that is true for all ZBAs, and that I point out that minority representation applies, but one thing, and I'll be touching on it again coming down, is requirement of the number of votes that you have to have. Most commissions are a majority of the quorum. But in your instance, you need 4 affirmative votes on both variances and on appeals if there were an appeal from an enforcement decision. The only things that you have that are just by, that are by just simple majority would be passing business, things like, adopting minutes and that sort of thing, or setting dates of meetings and agenda and that sort of thing. But the real guts of what you do, which is the variances and potential appeals from enforcement officer, you need 4 affirmative votes. I don't know whether your commission has this practice, but some boards, if for whatever reason people are not in attendance and you only have 4 people, or even sometimes that you say, you're going to need unanimous vote here.
We used to always explain that to them.
Yeah.
Because there was, 8, 9 months, 10, where we only had 4?
I want to say it might have been over a year.
Well,
where we
maybe
had-
8 meetings then.
Yeah, eight actual meetings, but yeah, we only had 4 members, and we would give them the opportunity, if they wanted to wait a month, maybe we would have another member.
Yep.
If not, we could do that, that night.
Well, I am
Cast a
the
lot.
last alternate member that's been on this board. We haven't had an alternate in a while.
So you can have, this is just touching on kind of meetings. This is a little more, this is really a combination of FOI and the statutes regarding ZBAs. But your meetings have to be open to the public. People, are not, when you get required to sign in or fill in any kind of questionnaires. People can come to your meetings and record if they wish to, as long as they're not interfering with your business. If they're walking around with a mini cam standing in your face to take the recording, that's obviously interfering with what you're doing. But if they politely come and sit down and put a tape recorder down right here, or sit in there with a tape recorder, or inobtrusively or videotaping the room, it's open to the public, so they have the ability to record it that way. Hey, Henry. So FOI requires that your votes be reduced to writing within 48 hours. Formal minutes, they come later, but initial minutes get prepared and get filed. And your decisions, just as Jonathan had indicated to the 2 folks that had gotten variances, your decision has to be published in a newspaper, because that gives an opportunity. If there's a denial, the applicant could take an appeal. If you get an approval, then a person who's aggrieved, which is usually abutting property owners or somebody within 100 feet, but it's not always just them. So you have to set your meeting schedule at the beginning of the year, and then once the meeting is scheduled, at a regular meeting, you can add items to agenda by 2/3 vote. Now, it tends to happen less with a ZBA than, say, a P&Z, because it's not like there's variance applications and appeals have to go to a public hearing. So it's not like somebody can say, hey, I want to get on the agenda tonight and be heard. So it doesn't happen that often. But if for some reason someone needed to add something to the agenda, let's say you wanted to do this training session and you found out, just a few days ago that I was available, and you had another agenda item that got canceled, and you say, hey, what do you say, have Slater come in? You could amend the agenda tonight, add this to the meeting, and you could do that. Special meetings, on the other hand, you can have them. You only need 24 hours notice. There's a little more notice that's required if you're doing a hybrid meeting or a virtual meeting, but the notice has to say when it is. Technically, it's supposed to, notice of special meetings are supposed to be actually delivered to the home of members. I find that to be uncommon, that go through that, as long as people know when it is and they're scheduled for it. But technically, that's what's required for special meetings.
You said that hybrid, you need a lot of.
Yes.
Time, do you want?
48 hours.
48 hours?
So, yeah, and not sure why, but you're taking away, why do you think you'd need more time to get ready if you wish to? If it's virtual or hybrid, either one of those, there has to be an additional 48 hours. But they built that into the statute that after COVID, when all the executive orders were established, in fact, my office worked with the governor's office, my partners Rich Roberts and I, to because the governor had no idea how municipal business, you know, how budgets get passed, how meetings are held. So we worked with them, and then after those executive orders allowing for things to happen, they decided, you know, this is kind of handy. There's different times people, some members of the public were, and there's increased attendance sometimes with some kinds of meetings because people were able to just log in from home. And then you might, you know, members who are, you know, like tonight, you have someone who it's more convenient to be able to participate through virtual means. So that got codified in the statutes, and when they did, they had that requirement of additional notice. So the time limits, the statutes, you know, have applied the same time limits now to all the land use commissions that, in your instance, all your real business is going to have a public hearing. The public hearing has to start within 65 days of acceptance. Now, acceptance is the date of the first regularly scheduled meeting, not special meeting, the regularly scheduled meeting after the documents are filed at the town hall, or 35 days, whatever is sooner. So for some reason, you know, you have a meeting canceled because of weather, and then this clock starts ticking, even though you might not have had that meeting and it got canceled, or maybe it's the summertime where you don't have a regularly scheduled meeting in August, if that's your practice of your commission, then the clock would start ticking automatically 35 days. You have to, then once from that point of time, you have to start your hearing within 65 days. And then once you start the hearing, it has to be completed by 35 days. And then once it's completed, you have 65 days for a decision. An applicant can give you an extension of time of up to 65 days for any of those deadlines, and could give you multiple ones. It give you a 2-week deadline extension for some reason, and then hold on to the rest of the dates. And then if for whatever reason you needed it, tends to be less necessary with a ZBA than sometimes with a planning and zoning. If the big presentation with all kinds of engineering and someone comes in with comments that have to make modifications, but it can happen with a variance application. There's information that you need that they have to get more detail on. Maybe they have to get a surveyor out there to answer some of your questions, and they need more time to do it. You have the ability to do that. And we always recommend that it be, you know, an extension be granted in writing. That's not legally required. If somebody says it's recorded and all that, they can be bound by it, but it's still a good practice to be able to put something in the file and not have to go back to a recording to determine whether or not a extension was allowed. And then this is the requirements for notice for publication for public hearings. And so the filling of vacancies is determined by statute. A lot of, sounds like for you had a period of time where you didn't have to worry about that because you didn't have an alternate to seat. But when you have multiple alternates, a lot of boards will sort of do a round robin, so people, are seated. But technically, a regular member, if they wish to, by statute, can designate, say, I'm not going to be at the next meeting, and I designate, board member blank to, or alternate member blank to serve in my stead. So that's allowed by statute. So you can't, one of the things when you serve on a land use board, you can't appear before other persons, on behalf of other persons in front of another land use agency. You don't check your rights at the door for yourself. I mean, if you were going to file an application with the Planning and Zoning Commission, or you wanted to oppose something that your next door neighbor was doing, you have the ability to appear on your own behalf, but you can't go to the P&Z because you have good experience in interpreting and understanding the regulations, and stand there and make the presentation on behalf of your neighbor. And that's true not just to ZBA, but each of the land use commissions.
Now, I had a question.
Yes.
When we only had 4 regular members, if I had to go against the board, that would never go through because there's only 3 members
Right.
to make the.
Exactly.
See, that's why I couldn't do it.
No.
Thanks for coming, Jared.
You need to make sure you get that other position filled, because you literally, if you were disqualified, and because you had a personal interest, because you have a financial interest in the application, then you need to step down. That's really your obligation to do that. And if that resulted in having only 3 members standing, so to speak, then it couldn't grant a variance, couldn't overturn an enforcement order.
Ken, we had some members previously, maybe some that are here now, who would be more sensitive on the biased question, and would go as far as saying, well, I live on the street. I live on the same street. We had a few of them who would go as far as saying, I live on the same street. I have no problem with you submitting your application. I have no problem hearing your application and weighing in and ultimately voting on your application, but would turn it to the applicant and ask the applicant if they wanted them to recuse, to get them on the record of saying, no, go ahead and do that. And that was some advice, I think, from previous legal counsel, particularly that it would make it so they couldn't appeal, to argue a bias after the fact.
That, you know what, that's a practice that judges do all the time, and so they would disclose, you know, I had actually, when I was in law school, a guy who became a judge and he headed up the complex land use docket for the state of Connecticut when they formed it. I was a student, and I actually was the first person to reverse a decision of his on in the land use matter. But when I would appear from him in court, he would sometimes say, you know, Attorney Slater was a student of mine, and I've known him for a long time, but I don't have, you know, there's no reason I feel that I would be unfair or I would be biased for or against him. But do you have any concerns, or do you think I should recuse myself? And they'd ask the litigant, and they would say no, and then that makes that issue go away. So if it's a close call, you know, because the case law, when you say people are super sensitive, there is no bright line about what's too close in terms of distance. I mean, I think it might be pretty obvious when you're literally the next door neighbor, but you know, you're a few hundred feet down the road. There's no, you know, each one gets decided on its own merits, and the court does defer in part if you say on the record, you know, I you know, considered this, and I really don't have any, you know, any bias for against the application, and I will consider it fairly. But if it's a close call and you do exactly what Jonathan suggests, and they say, you know, they could hurt themselves if you were in the position where they lose the essential vote if you were down to 4 persons. But if they said yes, no, I think you're not, you know, you're not able to sit because you have an inherent bias because of how close you live, then you'll know, and you could opt to do that. But if they say no problem, just as Jonathan suggests, that would take away their right to appeal on that ground because they had an opportunity in front of the board and agreed that there was no problem, so they couldn't change their mind simply because they're not happy with the result.
As long as it's in the public record.
Exactly. Yep, exactly. Just like you do right there. If I was, you know, that I was the variance application and then it's right down the road from you, you might say, you know, yeah, I'm a mile away. I really don't have any bias one way or the other. Do you have any concerns of my acting? And then I say, no, not at all. Then that would prevent me from successfully anyway. People make arguments, but successfully being able to challenge the board's decision because of a claim that you're biased.
The Yukon land use classes that I've been taking online too had an example of someone's, you know, a regular member sitting and then telling an alternate, no, I'm not going to vote, listening to the whole thing, and then tried to change their mind so they could vote, and that's something too that can't be done.
Yep. And you know, one of the things, if somebody does have a bias, I mean, we even recommend that if you have to recuse yourself, it's a good idea to leave the room. There's, you know, I was involved in a case where a member of Planning and Zoning Commission should have and did properly recuse himself, but there's in a configuration of the room pretty similar to me, sitting right about where that empty chair was, staring at the commission, nodding and putting his hand up at different times, and ended up having the decision reversed. So even though he recused himself, the court decided that he was unfairly trying to influence the decision. So what is a variance? And so it's an authorization to do something the regulations don't allow. And they're supposed to be granted only under exceptional difficulty or unusual hardship. Now, I'll give you a heads up that that, you know, the member of the executive committee of the Planning and Zoning section of the Bar Association. And it's been struggling with hardship. I mean, hardship from a very technical standpoint, as I'll discuss as I go through, but I'll also give you some practical advice also, is extraordinarily hard to meet. It's generally when you're going to be denied any reasonable use of your land. And so a proposal that some thought went too far in allowing a ZBA to grant variances, a legislative proposal was drafted a couple of years ago. And it died in part because there wasn't agreement among the members of the Bar Association and the legislatures, that the committee was involved to say, look, if you guys can't agree on this, you think the legislature's going to adopt this? So a new idea came out which might get floated, in which a commission, because there's very little case law on what exceptional difficulty means, there's an idea that the legislature can make an amendment in the statutes for ZBAs that say that a planning and zoning commission can define what exceptional difficulty means for its town. And so a ZBA, a P&Z who wants to give you a little more latitude and realizes that rather than, it can come down to the situation where if two applications are identical and one's got a neighbor that doesn't like it, the reality is if you grant a variance and they appeal it, they're probably going to win. I mean, most of the time, variances that are appealed, it's unlike, planning and zoning, it's just the opposite. Most decisions the Planning and Zoning Commission make when they're appealed are upheld. I mean, there are obviously plenty of exceptions to that, but generally, the odds are in their favor. The odds go the opposite for a ZBA because of how strict hardship is interpreted in the case law. So P&Z in some towns might say, no, I'm going to stick to straight hardship the way that it is, and they don't adopt it. Other towns who want to provide a little more flexibility, the P&Z could do that. And the nice part about that is if that happens, there's some towns where there's real animosity between a P&Z and a ZBA because the P&Z thinks the ZBA is giving out the store in variances. If a P&Z actually authorizes and comes up with the language that the ZBA is supposed to imply, it's going to make it less likely in a town like that. I don't think there's a lot of that here in Killingly, but if there was, it's an opportunity to allow for it easier to make it easier to get a variance, but not completely give up the store. They're supposed to be granted sparingly because generally you want people to follow the rules, and if they, and this is for the towns that have a problem with this, if they're so easily granted, the idea is that what's the point of the rules if the rules are really the exception? And then it says, this is in the case law. It's kind of vague what it means, but it should not be granted if it's inconsistent with the general purpose and intent of the regulations or would adversely affect the public health, safety, and property values. Technically, that's in the case law. It's usually, cases aren't usually decided on that one. Variance runs with the land, so it relates to the person. It doesn't relate to the person, it relates to the property. One exception is under federal law, if the person was seeking an accommodation under the Americans with Disabilities Act, for example, that's an instance. There actually was a ZBA case that was unrelated to Americans with Disability Act, where a ZBA granted a permit to basically Mrs. Smith to allow her to have this, this access, and that was overturned because it was supposed to be with the land. It didn't relate to Mrs. Smith. Well, the exception would be under the federal law if Mrs. Smith can demonstrate that needs some kind of an accommodation. And different towns can do it different ways. Sometimes that accommodation just comes from the zoning enforcement side and not in the form of a variance. But somebody could apply for a variance because they need a ramp that would be instructed in the setback that's not allowed, but that's the only way they can install it. You could grant a variance that applies just to Mrs. Smith, and then if the next person who owns there also had a disability, that's fine. And if not, the ramp would be removed.
Yeah,
Yes.
we did add that to our zoning regulations just to kind of cement the federal law and give direction to somebody seeking a reasonable accommodation, and it can be granted by the zoning officer.
There you go. Yeah.
Yeah.
And there's no right or wrong answer under federal law how that's done. So sometimes it's nice to have that very specifically stated in the regs.
Yeah, because I can remember one time I was liaison or on here already, that we, allowed a ramp, but told them that when it was no longer needed, it was going to have to be taken down.
And that would have been, because ordinarily you don't have to have a ramp to use your land, so it really probably would relate to the person who needed it, so it would be like an ADA accommodation. But now, what would happen is they would come to you under the P&Z regs, they would just go to the land use office, but it's exactly the same deal. You're supposed to state your reasons for granting them. I mean, sometimes they're self-explanatory. You decide that, that you've had the reasons given tonight that were very, articulate reasons for a decision. You're supposed to do that. So you're not supposed to, there's a thing called impotent to reverse. And what that means is administrative agencies are not, there's supposed to be some consistency over time in the way the regulations are applied. And it shouldn't bounce back and forth every time some commission members change or board members change. So ordinarily when a decision is made, it can't be reversed unless there's been a change of circumstances. And so that's a little different than, regulations say you're not supposed to reapply within a certain period of time. It's if ultimately all the issues presented and it's the same issue, even if you're allowed to reapply, the commission, just because 12 months has gone by or 2 years have gone by or 3 years have gone by, unless something has changed, you shouldn't reverse yourselves. There are some cases and some instances in which people were granting variances because it's de minimis, it's such a small amount. Now, the reality is people might not, this is sort of practical advice that would come in here, and it's what I'm sure you do, is someone's on a street, everybody has a garage, and there's because of a setback or what have you, or the way the lane is configured, you can't have a garage without a variance. Well, from a really hardcore, strict reading of Connecticut law, as long as you have your house, you don't have to have a garage. And so there would never be a legal entitlement to a variance. But practically speaking, if the thing, it looks like pretty much everybody else is in the neighborhood, everybody has one, the neighbors don't have a problem. Sometimes they come in and say, no, this is just great, please give them a variance. You folks grant them a variance, and the appeal period goes down. They get a variance, they put their garage up. It's kind of a common sense solution. The reality is, and this is the stuff that Bar Association and others are struggle with, is one neighbor who has two lovely neighbors wants to put the garage in and gets a variance. Just down the road, a couple people don't get along so well, and they ask for exactly the same thing, and the neighbor said, no, I'm going to appeal. Probably get reversed for the reason I just said, that you shouldn't be, no one's entitled to have a garage if they have their house, they have reasonable use of their land. So that's where you just use common sense, that even though I'm telling you there's probably something that would be reversed if it was challenged, if you use your common sense and something is a modest, they said no de minimis, but somebody needs to go in a few inches on a setback, otherwise they can't do something that seems very reasonable to do and nobody has a problem with it. Your variance would be valid if it's not challenged, even though technically if it was, it would probably get reversed. You can add conditions to a variance. It doesn't say so in the statute, but there's a case, so that basically the idea is, well, exactly as you presented it, I wouldn't give you a variance, but if you did this, then I will. And so it's essentially a condition to the approval. It has to relate to the variance. There was a case in which somebody put a condition, there was either the variance was about a sign and the problem was about the square footage in the building, or vice versa. But they granted a variance, but they said you had to resolve this other issue completely unrelated to the variance. That's not a proper condition. The condition would have to relate to the specific thing that you're doing. It's not a mother may I that I'll give you a variance if you do this completely unrelated thing on the property. If you do impose conditions, then the conditions have to be met before the variance, even though the could be recorded on the land records, as Jonathan said, if there's elements of things that have to be accomplished before you can do something authorized by the variance, those things obviously have to happen before the other activity is done, or otherwise it's in violation of the regulations. Use variances, they are authorized. I mean, technically it's supposed to be in situations in which you can demonstrate that the uses that are allowed in the zone you really can't use the property for that purpose. It has to be used in some other ways, or it can't be reasonably used. And if they can demonstrate that, then that would qualify them for a use variance. Zoning regulations can state that certain use variants are prohibited, in which case you wouldn't be authorized to do it. So hardships are supposed to be unique. Again, they come out of the specific land. So there should be something, if you have property that's configured with given wetlands, given ledge, given this, given that, you can't build on it. Sometimes in lake communities, you have situations where the lots are so small when they were built that when variances are established in a regular residential zone, setbacks literally cross each other. So you could never put any building on a lot but for a variance. So those things, tend to be unique to each property. Even though maybe there are others that might also qualify for variance, each lot's a little bit different. So the considerations are unique to that. Economic reasons are not legitimate basis. Financial advantage or disadvantage is not a proper consideration. Again, I'm turning back to your common sense. If somebody comes in and says, without this, it's going to, you're going to have to basically build a gigantic bridge, and it makes sense, and people don't have a problem with it, you can grant a variance. But if the reality is you could do it, it's just going to cost a lot more money than another manner, and that was challenged by a neighbor. First of all, I'll tell you, even if that is a factor in your mind, you shouldn't say it. You shouldn't come out and issue that as one of your reasons for consideration. I'm sure you can come up with other hardship grounds that might be supported other than that. And things that they're supposed to be unrelated to anything the owner has done or hasn't done. And that comes with the concept of a self-created hardship. If you go and you take your land and you carve it up, and you carve it up in such a way that you leave yourself with a lot that is really not buildable because of the features, et cetera, and then you come to the ZBA and you say, I want a variance, like, oh, wait a minute, that land could have been, the subdivision could have been configured completely differently, or your split could have been configured differently. There's even cases in which people have done work in a setback by mistake, and their surveyor has made a mistake, or their contractor has done it. A couple of cases have gone both ways on this one, but there's even case law that says it doesn't matter, that contractor is an extension of you. If you've created the problem, then you built it. You can't say that it's just going to cost a lot of money to move the building outside of the setback. It would be considered a self-created hardship. And it's also kind of come out of the regulations. Obviously, that it's something the regulations tell you you're supposed to do that you're not able to do, and you're not able to do for reasons that you didn't create. And this is what I already touched on, that bottom one, which is, like additions to buildings, things that, frankly, I'm sure you give hardships to when it's reasonable, but when the land is developed and it can be used, other improvements that are not in compliance with the regulations technically don't qualify for hardship. And you have to find it, so you should be always be referencing hardship and then the reasons for the hardship whenever you grant a variance. And it's the applicant's burden to do that. So, you're supposed to not substantially affect the comprehensive zoning plan. Well, the comprehensive zoning plan is amorphous. It just means with the regulations themselves. So if you do something that's, you're proposing something that's similar, you're going to end up with construction and use that's similar to what's going on and it's allowed in zoning and what's happening in the neighborhood, then you're not going to be, offending the overall comprehensive zoning plan. I mean, if somebody came in for a use variance and stuck, out of a sore thumb, you got some industrial use right in the middle of a residential neighborhood because they came and said that they really can't build a house here, but they can certainly sell sand and gravel. Well, that's when I think somebody would probably have a pretty good challenge that you've affected the comprehensive plan by granting a use variance to allow something that's so out of whack with what's right around it. Again, this ties to, an applicant should be, just kind of tying things back to the land and what's unusual and peculiar about its land related to the provisions of the zoning regulations to to prove a hardship. Again, tied to the financial issues before, competitive disadvantage, somebody, saying that somebody else is able to do something that they can't do. Well, if it's, the person might be better, better have purchased, more suitable property, but that's not necessarily a grounds for a variance.
I have a question,
Yes.
because you said that it should be depending just on the land.
Mhm.
But I know when we look at some things, we look at where their septic tank could be, this leach field, the well, so is that?
But see, that relates to the land, because
That's
if the
okay.
septic can't be constructed because of so much ledge, and you've got fantastic, it's a lot that's existed, and it turns out after they discover that there's all this ledge and things in the ground that wouldn't allow for a leach field, but they can squeeze one in, but the leaching field it's gonna require some construction in an area that wouldn't otherwise be allowed by the zoning regulations. That's still related to the land, so.
This is kind of what I was just looking at. This
Yeah,
was with
yeah.
the generator.
Yeah, because-
Right,
But
if
Yeah, it was
I can clarify,
Yeah,
you're
yeah.
asking that if the septic is an existing feature and that's why something can't be developed that way, is that a hardship that arises from the applicant because it's already?
That's why I had asked where the septic system was on the other one, because we usually take that into consideration when they're trying to put something in, because septic is here, well is here, you have so much footage around, so they can't put, in a certain spot.
basically-
Because
All
of
they
other
need is
people's
septic
septic
and that.
systems on
No,
the adjoining
because-
lots, or where he put it?
Because
Where
of
they're
their
at.
own. So somebody came in tonight and they had asked that we grant them a
But
variance
the
for the
generator doesn't matter
setback.
because it can be moved.
They wanted to expand their deck and they could only build it one direction because there was a pad with a generator and I think a propane tank and a septic.
An air conditioner.
Yeah, and an air conditioner. So would that be a hardship? Well, it's not a hardship because Lynn, I think, is asking is if that is considered arisen from their own actions because it was developed.
Yeah, probably, but this is, but
But they
this
did
is
put
one in
septic
which.
tank and leach field on here. That's what would let it go.
Well, no, that's what I'm asking. If that's where the septic tank and the leach field already were,
Yeah.
that's already the construction, and that was like you either bought the house like that
Yeah.
or you decided to put it there. So I don't see how that can't be considered arising from the actions of the applicant.
So it'd be maybe more a question of like, did you put the generator there? While you own the home, did you put these things that are now, in theory, maybe creating the need for a
Sure.
variance?
Yeah.
But,
The
I mean,
hardship.
if the prior owner did it, it still kind of runs with the land.
Okay.
So, but again, that's why, sometimes you've got to be real careful, and you haven't asked for an opinion of whether something's legal hardship, because there's certainly going to be times, if you had, you're probably going to get an answer from us that says, no, it's not. When on the other hand, you presented a plan, you looked at it, it seemed reasonable under all things that this is something that your board should weigh in on and give them some relief, and you did.
Well, so in this particular case too, to add to, this was already a non-conforming lot. So if it wouldn't even affect the setback
Excuse-
if it was conforming.
I'm sorry to interrupt you, but should we not be speaking in hypotheticals at this point?
Yeah.
Okay, we're speaking in hypotheticals.
Okay.
Well, to tell you the honest truth, it doesn't make a whole hell of a lot of difference, because if somebody decides to take an appeal from it, they're gonna take an appeal from it, but I guess understand what you're
I'm
saying.
sorry, I'm just trying to use an
No.
example, a recent example, that's all.
No, when I say not a whole lot, if what I'm saying, is
Same
the,
question.
you look at the totality of of all the factors, and you look at it, and it's a reasonable plan, and there are some unique elements of what's there on the site, where things are, where the distances are, then, that's a plausible, reasonable basis for granting a variance.
Okay.
But most of the time, and maybe even including this time, the practical reality is if a neighbor has a problem and takes an appeal, they've got a big leg up based on how harsh the law of, they could even go so far as to say, hey, there's an existing house, so any addition is not necessary because you've got reasonable use of the land. That argument can always be made. So they are tough. Variances are tough to defend, but I haven't had to defend any of yours. So the fact that, you pay attention, you you listen and you look at the instances in which it seems to be fair and reasonable, then you're less likely to generate appeals, and, you help people out. And that's, the nice thing about what you do as a board. Got another financial thing. There was some case about proof. The fact that you can't use your land absent a variance. Well, that is a kind of financial consideration, but that's at the heart of what a variance is. If you can't get any reasonable economic use of your land, then that's okay. This references a variance for a rooming house where the building was functionally obsolete and could not have. There was retail businesses or commercial offices were allowed, but there was enough evidence to demonstrate that that the rooming house could be allowed. Now, there's an example where it's a building, so to your question a few minutes ago about the existing septic. Well, there was part of it was how the property was already improved. Somebody could make an argument, wait a minute, that's the way they approved it. But they were able to, that under all of the facts in that case, they put enough evidence in that you couldn't reasonably use the land for retail business and commercial offices, and the consideration about the way the property was improved was factored in. Another one, condemnation is an instance in which there's actually no hardship required if the result, it's anything but self-created. If the government comes and takes part of your land and now makes it partially non-compliant or more difficult to develop, you can grant a variance related to the state condemnation. Classic areas, narrowness, topography, where you can't really construct because of circumstances on the land. That's a classic basis for a hardship. Now, one that there's a case called Adelson, and that number 4 is elimination or reduction of non-conforming uses. There's a case that said that if you come in with a plan that's going to reduce the number of existing legal nonconformities, so pre-existing issues that are not in compliance. Technically you wouldn't normally be able to build within a setback, but if you come in with a plan that involves doing construction in a setback, but you're doing it in such a way so that instead of having 500 square feet in intruding into the setback, it's going to be 250. Well, building in the setback maybe wouldn't qualify if you wanted to do it by itself for a variance, but when it's in conjunction with getting rid of some other nonconformings, the Adelson says that you don't have to find a hardship to be able to do that.
That goes as far as questioning whether or not they need to even seek a variance, correct?
Well, if what they're going to do, let's say in my scenario, there's a non-conforming shed, and it's very close to a neighboring property owner, and my proposal is I'd really like to do a bump out on my house that's within the setback. I'll take the shed down. This is a little horse trading. I'll take the shed down that is X number of square feet and is closer to the boundary, but I'll just put in this little tiny bump out on my house. Under Adelson, if in the net result is less nonconformity with the regulations than it was before, then the idea is you made things a little bit better. Whereas if you didn't have that shed and you wanted to put that bump out in the setback, you wouldn't have qualified for a variance without a hardship.
Also, if you improve a property that's non-conforming and you make it conforming, you can't turn around and make it non-conforming again, correct?
That is correct. Yep, that is absolutely correct. So these come out of cases, so I'm not just inventing these, but examples where the courts found that there wasn't hardship. Somebody claimed, I've been paying taxes. The assessor has been assessing me for having 2 building lots for all these years. Now I come in and you tell me that it doesn't, this parcel doesn't comply with zoning. Please give me a variance. No, that's not, the way it's been assessed. You could have figured that out and then gone to the assessor and said there's only one buildable lot and had your assessment adjusted. What happens in the assessment office really has nothing to do with zoning. Somebody came in and had one of the highest tax bills because of an assessment calculation. Not allowed, just because of that doesn't mean you're allowed to be able to split it into a couple of lots. Construction when owner should have known there was a zoning violation. So sometimes there's a concept of what's called municipal estoppel, which is if someone reasonably relies on municipal staff and goes ahead and makes an improvement that's in violation of the zoning regulations, a town can be what's called a stop, which is mean prevented by, not allowed by the court, to stop it, and the person can go ahead and finish construction it because they reasonably relied on that. But if the person knew that it was a zoning violation and somehow got away with getting an approval, or should have known even, if a simple view of the regulation, the zoning enforcement officer was just not killing land, the zoning enforcement officer was a knucklehead and issued a permit that was clearly in violation, and anybody would know it, you can't blame the enforcement official. The construction, again, other than Adolphson, usually construction within a setback is not something you'd be able to prove that there's a hardship. That said, my guess is you probably have, and I would suspect every ZBA in the state has at some point. Sale of, this again, no hardship. Sale of some of the property leaves the other when I say non-conforming, normally non-conforming means pre-existing legal, but this is you result in a lot that is undersized or doesn't have enough frontage or what have you. If you've left yourself with land that doesn't meet the regs, that's classic self-created hardship. And I've already talked about financial issues. And I've already talked about Adelson, so I can bump past that one. And I'm on a run now. The Americans with Disabilities Act, in this case, because of the zoning regulations, it's not going to come before you. It'll something that the enforcement officer will handle. And I've touched on this, practical, just be reasonable, practical, and use common sense. And that's really what's going to keep you out of trouble. One recommendation is that if you can, be careful to have your variances tied to the plans, to specific plans. There was a case in which somebody came in and said, I want a 3-foot a 3-foot variance on my property. It was granted. Right? They had a specific plan, and that's typically the case. The ZBA looks at it, okay, why do you want the 3-foot? And so they did have their reason for the plan. Well, the commission just granted this variance, and that resulted in changing the setback for the entire lot. And so they can come in with any plan to develop anywhere within that setback. Whereas if you tie it, I'm granting a variance to allow, what's shown on the plan, then they would have to come back with something, a new plan if they were going to do some other work that close to the setback. Okay, now we'll talk a little bit about what you don't do very often and hopefully won't have to do, and that is having appeals from the enforcement officer's decision. So that's a role in which you act more like a judge than reviewing a land use application, and that's what they call it in the cases of a quasi judicial capacity. So the administrative officer issues. Pretty much anything a zoning enforcement officer puts in writing is appealable. It can be on a napkin. And so if that decision gets appealed to you, you act, you basically step in the shoes. A lot of times when it happens, the zoning enforcement officer feels like you're trying to decide, if, Jonathan was right or wrong in issuing his decision. And that's actually not what you do. What you do is you step into the shoes of Jonathan and you have a whole new hearing. And you're going to hear all of the evidence. And what sometimes happens is the information Jonathan had when he made his decision is a little bit different than what comes out in front of you. So maybe there's something that would have come, had it been given to Jonathan, he might have decided differently. And so what should happen is, the thing comes before you. Jonathan might present all his information regarding the site and the reasons why the decision he made. The applicant gets to present his or her or its information, and the public gets to present all their information. Once you have all of that from the hearing, you decide whether or not it's in compliance with the regulations. You're not deciding, like, if your decision is appealed to the Superior Court, the Superior Court's job is not to step in your shoes. It's not supposed to re-decide the case. It's supposed to look and see whether or not you had a legally valid reason for your decision, A, and B, whether that legally valid decision is supported by substantial evidence, which means there's got to be real evidence in the record to support you. Even though two people might disagree, if they heard the same evidence, they're not going to, he's not going to revisit the ball and the strike. And so, going back now to you again, when you're in the role of reviewing a ZBA, you are literally becoming the umpire, and you call the ball and the strike yourself. In fact, you could even, the enforcement officer, maybe you'll agree that there's a violation, but maybe exactly what the ZEO was requiring, you think might have been not exactly right, or maybe too strict, or this or that. You're going to issue a whole new decision, which is in place of the one that Jonathan would have issued.
See, I understood actual appeals, not variances that come to us. Like, I thought we were supposed to look over if there was a procedural issue with the original decision, and then examine that. I didn't.
Nope.
Okay.
Nope. You're supposed to. I mean, the procedure. I mean, there could have. I mean, sometimes the decision, might involve procedure in the sense of, but it's still compliance with the zoning regulations. So it's very clear this de novo, which means from, I believe, I didn't study Latin, but I think de novo means from the beginning.
Right.
So you get a completely clean slate, and you folks have to make your own decision. I mean, quite often, the zone enforcement officers are professionals. This is what they do, and frankly, in my experience, far more often than not, when an appeal is made, a zoning board of appeals affirms the decision. So that sounds like it's an appeal, and you've endorsed what he decided. But the way you're supposed to do it, if you affirm the decision, is you're supposed to give your reasons as to why it's in compliance with the regulations, not the reasons why you think Jonathan decided correctly based on what he had. So sometimes somebody gets an order and they will appeal it, but then alternatively will file an application for a variance to allow it. If that happens, you should decide the appeal first, because it's possible after you get all the evidence, you find it's in compliance. It's better to be in compliance than have to get a variance. So, again, more often than not, you're going to find that the zoning enforcement officer was correct. Then you could go into the next step. Would they be able to demonstrate that there's sufficient hardship to warrant a variance to allow it anyway? Now, one thing, and we deal with that with towns we represent. You've got a neighbor that's really upset about something going on with another neighbor, and the enforcement officer doesn't issue a decision. I mean, so the neighbor wants the zoning enforcement officer, to make a finding, and opts not to. Maybe the bigger fish to fry. Got other stuff to do. We don't want to get in the middle of this one. And the lack of a decision on the part of an enforcement officer is not appealable. So it's been tried. People have taken an appeal from the inaction, and that's not. It's not appealable. And that's the end of my show, except for any questions on topics I might not have covered.
I thought it was funny when you talk about the law, because 2 years ago, I got my insomnia reading.
There you go. It's coming up again this year. That was one of the guys that sat behind Rich Roberts, my colleague, who was actually the guy I mentioned before that we worked together on, and he's one of the guys on if you're watching the Land Use Academy videos, he does the one on conflicts of interest and those, which I think is what you were referencing. He'll do one of the presentations in there, and I'm sitting behind the scenes now that in the virtual world, it's actually pretty nice because people are making, in real time questions and something that, the presenters are still going on and saying their thing. Meanwhile, I'm banging away answering somebody's question on something that just somebody talked about. So it's worked out well. We've got good feedback on the, it used to be, I don't know if everybody went to the old Wesleyan one, so we still call it the Wesleyan session because it used to be in the big auditorium, and then there was an overflow room, and people would have a nice lunch. So some people miss the fact that they didn't get together and have the nice lunch. But overall,
We
the
serve
ability of
pizza.
more people to participate. Was that?
We serve pizza.
Oh, there you go.
We kind of
So-
keep that spirit alive, so
There you go.
we
Good.
invite all the members to attend in person. We'll be looking to do a head count and everything, and so we can get books ordered and everything like that. The meeting is generally, we do open it to the public in a sense, but it's not a meeting of the board.
Right.
It's just a training, it's just
Yep.
open. It most likely will be held in this room, and we get to watch it on the TV.
There you go. And if you stump me, I'll on the keyboard, I'll compliment you.
What subject are you doing?
What's that?
What subject are you doing?
I'm not doing any. I'll be there all day
Oh, okay.
behind the scenes
Just
doing
answer
things. So I help organize it. Mark Branson and I and woman Shirley Perrin from the ZBA, from the Planning and Zone, or the CBA, do a lot of the organization and get everybody to update their presentations and organize the speakers and make sure the
Just ask
trains
them
are on time. So then once it's
controversial-
happened, then we sit there and people who put comments and things. I mean, every now and then you could see the same person's trying to find somebody to tell them the answer that they want to hear, and we'll kind of filter that out also. But most all of the questions are legit good questions that we try to answer in real time behind the scenes.
Try to
behind
ask
the
some
computer.
controversial ones that I know you and your colleagues disagree on.
There you go. That's for sure.
I have one quick question. Because when we register people, I have to give, and this is just for the Connecticut Bar Association, I have to give their emails because they have to be able to notify them. Is it okay if we just have a sign-in sheet here and they can just sit here with all of us because they're saying they can't quote-unquote give them credits, but we can report that they were all here? Are we all set with that as far as the state goes?
So are you going to collect their email addresses, or the folks don't want to give you the email addresses? Is that? what's
No,
the
they
issue?
want to give me the email addresses, but nobody wants to sit home alone. They all want to come
yeah.
here. So
No.
what we do is we have a sign-in sheet, and they sign in saying that we came in and that we left.
Would you mind sending me an email in the morning? Because I'll pass that on to Shirley and just confirm what's the
Okay.
best way for you to be able to document that so that everybody doesn't have to
Because
log in
and I'm sure
separately.
there are other towns that are doing it
Mm-hmm.
and want to do it, and they're nervous to do it because they don't know if it's going to affect, does the credit have to be through their computer, or can it just be through us with a signature? Because the way the state statute has the recording or the reporting of the educational, that's, there's no real
Yep.
thing.
Yeah.
Okay.
It's kind of similar, like even during the course of the meeting, like Anne Marie most likely will log in to, get Casio credits, and I'll be logging in as well to get Casio and APA credits, and I'll probably have both the computers here as well as, one of them will probably be the one that's,
Right, that's
projecting.
actually operating
Yeah.
this device. Yeah,
But
if you
it's
could.
just to make it convenient for commission and board members, and so they have that, I guess, misery loves company.
Yeah, camaraderie, though, right?
Companionship,
Yeah, yeah.
camaraderie. They like to come here. It gets them out of the house, gets them away from the dog, gets them away from
Yeah,
the
get
kids.
some pizza.
Yep.
So. All right, folks, I enjoyed meeting you, and certainly going forward, to the extent you have questions, go through staff and can help you out, but I enjoyed the opportunity to give you my pitch. So,
Thank you, Ken.
Thank you.
Thank you,
Thank
Ken,
you.
we appreciate that.
my pleasure.
Ken, did you get the email from me late this afternoon?
No,
You did, or
I'm
no?
sure I got it, but I haven't seen it.
Okay.
No, I was in a meeting, a good chunk of the afternoon. Do you want me to deal with it now, or do you want
Motion to close
No,
new
I can
business.
just, one quick question. One quick question. How many of you are willing to come in, and you too, Mr. Dave, David Izzo. How many of you are willing to come in on the 22nd, or how many of you at least want the book for the March 22nd? You're,
I'll come in.
okay. Jared, Andrew, all of you, okay. Dave, I'm going to
Yeah,
put you
I'll
on.
come in.
Okay, thank you.
You're welcome.
On to Article 7, adoption of the minutes from November 1st, 2024, our special meeting. Roll call vote? Oh, yeah.
Thank you.
I'll make a motion that we accept the minutes of Thursday, November 21st, 2024.
I'll second it.
Roll call vote?
David Izzo? Oh, sorry.
We're going to do a discussion. Is there any corrections, David, that you have for the minutes?
No, I just seconded, no.
Okay, anybody here? No. Okay. Now we'll do a roll call vote.
David Izzo?
Yes,
Linda Burge?
Yes.
Bill Mengy?
Yes.
Jared Peachy?
Yes.
And Andrew Farner.
Yes.
Motion carries unanimously.
On to Article 8, correspondence to the board.
I have nothing separate for you guys. As was earlier stated, we're going to be looking to do another training in March, and I'll look to pass that information on to you. It is on a Saturday. We'll have an option to do in person, but if for some reason you would like, you can log on remotely directly through Connecticut Bar Association. I believe they also record that if for some reason you really needed to go.
What time is it at, March
It is
22nd?
it is like an 8 to 3 or 8 to 4.
That was 9 to 4.
So I will not be there.
Yeah, it's a longer day. We
Actually, I
will
have a
we
funeral
will
on March
usually
22nd.
we'll sign you all up just so that way everyone gets a book. There's no
She used to be
cost
my lunch
difference
lady.
there, so we want to make sure everyone at least gets one of the books. Lynn has the one from 2 years ago here, so it's nice to have. But I'll pass along the information. I have a flyer in my office. I'll shoot you that. Otherwise, I don't have anything new. If you guys, yep,
John, is that the one that we had a couple of years back?
The black one?
yes, sir.
Old-age training?
Yep. Yep.
It's the same thing, we have to get recertified in it?
It counts towards your training for the state.
Okay.
So they're going to cover a variety of topics. I'm going to get you guys all just the flyer for it. I'll shoot out an email tomorrow with that.
Okay, thank you.
Yep. Otherwise, I don't have anything else, and I'm not seeing a council liaison here. So unless you guys have any questions about anything going on in town, I can do my best to answer those. But otherwise, we'd be at adjournment.
Article 10, adjournment. Do we have a motion?
So moved.
Second.
No. Aye. All in favor?
Aye.
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 Bye.
Thank you, Joe.